What's going on, everybody? Aaron here with Tier 1 Academy, and today we got some interesting stuff happening here in the firearms world. Alright, let's talk about it. So, what just recently happened was a Virginia federal court has challenged Maryland's handgun laws, particularly pertaining to the HQL. Now, for those of us who don't live in the state of Maryland, live in the state of Maryland, but aren't really sure what all this means, or are interested in getting your HQL, but now you're not so sure because of all this new stuff that's going on, we're going to go ahead and talk about it. But before we do that, in order to really understand the significance of this new ruling, we have to break down the history of the HQL. So, what happened was, 10 years ago, Maryland lawmakers passed a law saying in order for you to purchase a handgun or small caliber firearms here in the state of Maryland, you have to have something that's called an HQL, which is short for Handgun Qualification License. So, in order to obtain the HQL here in the state of Maryland, all you have to do is take a 4-hour class with a certified handgun instructor from the state of Maryland, like myself, shoot one bullet out of a handgun, send your paperwork off to Maryland State Police. They do your background investigation. Then 30 days later, or 60 days later, however long they decide to take, you then get your HQL in the mail. And all the HQL is basically a social security card, well, social security number from Maryland that says, hey, we, Maryland State Police, approve this person to be able to purchase a handgun. And then you take that HQL to a firearms instructor, to a firearms dealer. You show them your HQL number, they put the paperwork in, bada bing, bada boom. All right, too easy. Now, the main problem with this is that it does impede on your ability in order to purchase a handgun. Because without it, you can't purchase a handgun, okay? It's being gatekept by the state of Maryland, which is unconstitutional because it impedes on your Second Amendment rights. So, that's the HQL in a nutshell, all right? But what just recently happened was on November 21st, 2023, a U.S. Court of Appeals for the Fourth Circuit rendered a decision in a case questioning the constitutionality of a handgun qualification license, codified in Maryland Public Safety Article 5-117.1. The Fourth Circuit Court's opinion is that the HQL law is unconstitutional. At this time, the HQL law remains in effect and there are no immediate changes in the process to purchase a firearm in Maryland. The opinion of the Fourth Circuit does not become effective until the court issues a mandate. All right, so even though now the law is being challenged and there may be some changes going into the future, as of today when this video is uploaded, you still need your HQL in order to purchase a firearm, purchase a handgun or small caliber firearms here in the state of Maryland, okay? But however, if you want to save yourself a couple bucks, so that way you can put that money towards a firearm in the future, maybe you want to wait to see how this plays out and if that mandate does get passed, because it's already been made clear by Maryland politicians, especially the Governor Moore, I believe his name is. Yes, Governor Moore, is that they're going to challenge this, they're going to fight it. So we'll see how this plays out in the future, but that's what's going on today as far as the HQL. Yep, so let's further deep dive into this and see what's going on. Courtesy of the Washington Post, federal judges overturn Maryland handgun licensing law. A federal appeals court overturned one of Maryland's toughest gun control laws Tuesday, saying the decade-old handgun licensing statute that required fingerprinting, firearms training, and a waiting period of up to a month violated the Second Amendment. That's because it kind of does. The ruling from the U.S. Court of Appeals for the Fourth Circuit is among the first to strike down handgun permit requirements under a legal test established by the Supreme Court in 2022 that requires judges to consider whether modern-day regulations mirror what was in place around the time of the country's founding. The panel voted 2-1 to block Maryland's enforcement of a key part of a 2013 law that was passed by Democratic legislators after the 2012 shooting at Sandy Hook Elementary School in Connecticut. It required that handgun buyers who already faced background checks and waiting periods for purchases obtained an additional handgun qualification license from Maryland officials and wait up to 30 days to have it approved. When the law was passed, advocates heralded the extra steps as a way to deal with straw purchasers who bought guns on behalf of people who could not pass a background check. The Fourth Circuit judges said in their opinion Tuesday that the prospect of waiting 30 days for a permit abridged gun buyers' rights to keep and bear arms. More than 315,700 permits have been issued by the Maryland State Police since the law took effect, the agency said Tuesday. The law's waiting period could well be a critical time in which the applicant expects to face danger, the appeals court stated. Gun rights advocates have argued in courts across the country that dozens of long-standing state and federal gun laws cannot survive the Supreme Court's new historical test, and judges, at times reluctantly, have agreed in cases affecting age restrictions for handgun purchases and kinds of sensitive places where guns can legally be banned, and the kinds of convictions for which states can ban people from possessing guns under New York State Rifle and Pistol Association, Inc. versus Bruin. The landmark 2022 ruling that said gun restrictions were unconstitutional unless they were already in place around the time of the Second Amendment's adoption or were closely analogous to colonial era restrictions. So I want to talk about this part right here, which is the law's waiting period could well be a critical time in which the applicant expects to face danger. The answer is yes, because most people buy a handgun or seek the need for a handgun in response to some type of new development, whether it be their life was threatened, they feel unsafe, they feel uneasy, they got internet stalker, etc., etc. Reasons vary. But if that person feels the need to purchase that handgun to defend themselves, and then they have to wait a month and a half, after taking my 4-hour class, then waiting 30 days to be approved by Maryland State Police, then having to wait 7 days to actually go after the day of purchase, then pick up the firearm, that's about a month and a half. Something could have happened to them in between that time, so that does impede on their right to self-defense, and to a degree, their rights to bear arms. In a follow-up case, the experts say tests the reach of the High Court's Bruin decision. The justices are weighing whether domestic violence offenders can be legally disarmed. We can have the conversation. Maryland Governor Wes Moore and Attorney General Anthony G. Brown, both Democrats, each said Tuesday that they are evaluating their appeal options. Maryland gun rights activists and the National Rifle Association celebrate the decision. This makes it very clear that the state cannot erect obstacles, said Mark Penn, the president of Maryland Shall Issue, and one of the plaintiffs who first challenged the gun licensing law in 2013. The right to keep and bear arms necessitates the ability to acquire them. You cannot keep and bear that which you cannot acquire. This is 100% true. You don't have a right to bear arms if you cannot obtain the arms if you cannot obtain the firearm without taking my class. So it does impede on your Second Amendment right. Deep Blue, Maryland has some of the toughest gun laws in the country, according to Everytown for Gun Safety, a gun control advocacy group. Democrat lawmakers here have been scrambling to fortify the rules as the Bruin proceeding eroded their confidence that the laws would be upheld in court. Lawmakers could also attempt to rewrite the gun licensing law to satisfy the judges. We'll have to look at this in subsequent decisions in the months ahead. We're in uncharted waters, said State Senator William C. Smith Jr. of Montgomery County. It's always Montgomery County. Chairman of the Judicial Proceedings Committee, whose panel has jurisdiction over the Maryland gun laws. Separate Maryland laws prohibiting a handgun purchase without a 7-day wait or background check by the Maryland State Police were not affected by the ruling. So, again, this is not really challenging the waiting period and a little bit of philosophies behind that. It's just more so the person's ability to acquire the firearm in the first place, which they cannot without that HQL, which impedes on their Second Amendment rights to a degree, and especially on their rights to self-defense. Maryland Democrats were quick to condemn the court's decision, with Senator Chris Von Hollen calling it yet another disastrous consequence of the absurd new Supreme Court standard that today's gun laws need to match those from centuries ago. And Baltimore Mayor Brandon Scott saying in a statement, "We should be more, not less careful about who has access to those tools of violence." Mayor Brandon Scott. What just recently happened in your city is a shooting happened next to Morgan State University. For starters, there shouldn't be no firearms even on campus, let alone near the campus. Second, the shooting happened by people who were not 21. Here in the state of Maryland, you have to be at least 21 in order to own a firearm. This happened by guys who were 18 years old. So, what about firearms not being in the right hands? Because the law already prohibits them from having it. So, how do they have it? I can tell you why they have it, because you're not tough on crime. That's your problem, not people's ability to possess it on a firearm, but you not being tough on crime. Let's proceed. Moore called the decision disappointing and promised to fight for the law. This law is not about stripping away rights from responsible gun owners. It is about every Marylander having the right to live free from fear, he said. How are they living free from fear when crime, break-ins, carjackings are at an all-time high? Crime is only growing. So how are we living free from fear? Because you're not tough on crime. That's the real problem. Marylanders are already in fear. That's why they're out here trying to buy handguns. So that way they can protect themselves, because you can't protect us. Because you're not tough on crime. You're just letting people out here do as they please. You messed up the bail system, because so now people are just repeat offenders. You're not tough on crime, so these guys already know, hey, I'm going to do this crime, I'm going to do whatever I want, and I'm going to get away with it, and if I get locked, I'm going to get right back out, or I'm going to get a slap on the wrist. That's why everyone's in fear. That's why people are trying to buy firearms today, that way they can protect themselves. So you're missing the mark here, sir. Two other Maryland laws face similar legal challenges from the same guns rights activists who took issue with the license law. The Fourth Circuit is weighing a challenge on Maryland's 2013 ban on the sale of assault weapons and a sensitive place law enacted this year to limit where guns can be carried in public by those with concealed carry permits. The latter was a direct result of the ruling affecting Maryland's concealed carry law. So yes, so what happened in New York affected Maryland. That's why Governor Hogan, about a year ago, passed a new law where saying you no longer need a substantial good reason or to get a CCW here in the state of Maryland, which is why a lot of people went out and then got their CCW, because they want the right to defend themselves, the right to protect themselves. But it was clearly done to try and keep the federal government off their back. But again, the federal government's still seeing this. Well, federal courts are still seeing this and saying, hey, still some of the stuff is not right, because you're still impeding on some people's ability in order to obtain a firearm and the ability to protect themselves. Yep. So I'm going to go ahead and leave it there. So we see the philosophy. We see what their philosophy is, which is we're trying to keep Americans safe. We're trying to keep Marylanders safe, but they're doing a pretty crappy job at that. We also see that they said they're going to fight this. So don't hold your breath on the HQL being banned. Well, I'm sorry, on the lack of a need for the HQL, because they're going to probably fight this tooth and nail. So don't hold your breath. If you still want a firearm, still go out and go get your HQL. But if you say, I don't really need a firearm yet, I just want to go ahead and wait it out, then go ahead and wait it out and possibly save yourself a couple bucks. So I'll leave it there. Again, my name is Aaron with Tier 1 Academy. Thanks for watching. Stay tuned. We're going to stay on top of this and see what updates come along. And we're going to update you guys with those updates. And we'll see how it goes. And we're just going to hope for the best. All right, thanks for watching. Have a wonderful day.